like to call the March 27, 28. Please call the roll.
On the call the roll, Member Wolf. Wolf is not present at this time, but he is on his way at this moment. Member Hinsey.
Here.
Hinsey present. Chair Tesfa.
Present.
Tesfa present. We have a quorum. There are no agenda changes that I know of at this time. Next on the agenda is item number 2, approval of the February 27, 2018 Complaint Committee meeting minutes.
Do we have a motion?
I'll move to approve the minutes.
I'd second that motion. Do we have any public comment on that motion? That's for the approval of the February 27, 2018 Complaint Committee meeting minutes. Seeing none, can you call the roll?
On that motion, Member Wolf. Wolf absent. Member Hinsey.
Aye.
Hinsey, aye. Chair Tesfa.
Aye.
Tesfa, aye. The motion passes. Next on the agenda is item number 3, public comment. Members of the public may address the committee on matters that are within the committee's jurisdiction but not on today's agenda.
Hi. I have some issues with the Arts Commission, as you well know. Ann Trickey, who I don't know, an employee there probably for about 2 years, she seems to spend a lot of time. I have a website, and in this past week, she contacted the server of the website that I have. I posted the 33 orders of determination issued by the Sunshine Task Force on my website, and she's been trying to remove them. I got notice this morning. The reason she wants them removed is she claimed trademark infringement. There's no trademark infringement involved. So this morning, I went up to the website's administrator. It's located in the Presidio. It just happens to be in San Francisco. And Ann Trickey is kind of been banned from my site for posting slander and personal attacks. So both Ann Trickey and Kate Patterson Murphy, don't know both of them except to see them here, have acted on their own at Sunshine hearings. They've never consulted with the San Francisco City Attorney's Office, though they claim they did, and cite sections of California codes that don't exist. And even after orders issue, they make the same mistake over and over again. It's very frustrating on my part. Okay.
Would you like to offer those comments in writing? Is that what that is?
Yeah, that's a written.
Okay, thank you. Thank you. Do we have any other public comment? Seeing no further public comment is closed. I'd like to move to item number 4.
Next on the agenda is file number 17134, complaint filed by Thomas Bussey against the San Francisco Public Utilities Commission for allegedly violating Administrative Code Section 67.21, 67.24 G&I, and 67.27 by failing to respond to a public request in a timely and/or complete manner. At the last meeting of the task force, you did determine that the task force has jurisdiction, and we are here to review the matter at this time. And I did mention via email to the chair that there may be a request from the respondent to possibly continue this matter, but that is your decision to make.
Thank you.
I believe 5 minutes.
Okay. 5, okay, well. To summarize, last year I made a Sunshine Ordinance request for the PUC's dam failure emergency action plans. The SFPUC failed to release these public records. In the jurisdiction hearing, we heard from the PUC that they claimed a new exemption in the Emergency Services Act. The law is actually not that simple. The PUC took 24 business days and obtained an undisclosed memorandum from the city attorney before it decided to refuse my request. Certainly, in that time, the PUC could have simply redacted any sensitive information. But as of the events last week, the urgency of disclosing the emergency action plan for dam breaches is a little bit more important. Via certified letter, I described the problems with the PUC's interpretation of the Emergency Services Act to this task force, and I was disheartened it was not included in the packet last time. Just as I was disheartened, I was not notified about your hearing on my complaint about the Public Finance Authority. But to summarize my legal opinion, SB 92 states that the Governor's Officer of Emergency Services will treat an emergency action plan filed by a private dam owner as confidential. It did nothing about the SFPUC's legal duty to disclose under Section 67. The precise legal question as I have framed it, and for you to consider, is: are the legislature's constitutionally mandated findings pursuant to the 2004 California Sunshine Amendment sufficiently like the CPRA balancing test exemption so that the Emergency Services Act exemption may not be invoked under Section 67? The job of the task force is not to penalize or act as a judicial body over public servants. The job of the task force is to report to the Board of Supervisors and the public problems with open government, limitations on sunshine. As the events of last week attest, where an SFPUC dam was in imminent failure, imminent danger of being breached, this is a problem. And I urge the task force to raise the issue with the Board of Supervisors to inform them that the emergency action plans are not available for public review, so that they might even consider looking at them and even review them in private. AB 1317 by Assemblymember Jim Frazier added the original emergency action plans to the Emergency Services Act in 2013. He tucked it in among an implementation of Governor Brown's executive reorganization. Frazier ignored the July 2013 FEMA guidelines regarding inundation mapping and flood risks, and the resulting emergency action plans and flood maps were horribly inadequate, or I'm going to say embarrassing. Post-Oroville, emergency regulations went into effect on October 1st, 2017 to fix the problem. The 2013 action plans adopted simplified dam inundation maps. These take the acronym SIMS. Creating a SimCity inundation map involves tweaking a few settings in Google Earth and exporting it to Adobe, making a few strokes with a paintbrush tool, throwing the whole thing bamboozle into a so-called high-tech template developed by a Liberty, Missouri PR firm called Creative Communication Network Incorporated. This is owned and operated by an unregistered agribusiness lobbyist named Ron Butler, who is a side hustler, runs seminars on the 15-minute business plan for consultants to obtain inflated public contracts. Today, Butler's clients include Universal Foods, BASF, Sanofi Animal Health, Monsanto, the American Soybean Association, the Agrogenetic Seed Corporation, Sandoz Crop Protection Corporation, International Multifoods, and the list goes on and on. Why is this guy asking about dam safety? It was discovered that the state of California had tons of these SIMS map on file, and for a private dam owner, it is much cheaper to take 15 minutes to throw together a SimCity emergency action plan rather than follow FEMA's guideline and hire real engineers. Was Moccasin one such map? It is therefore unsurprising to find many of Butler's agribusiness clients and Creative Communications Networks Incorporated's lobbyist staff among the donors to Assemblyman Jim Frazier, who set the guidelines. So let me be clear. Protecting public safety has nothing to do with the PUC's refusal to release the emergency action plans, and it has everything to do with protecting inflated pay-to-play contracts for Ron Butler's cronies. Thank you.
Is anyone here on behalf of the respondent?
Hi, good afternoon. I'm Mary Ellen Carroll with SFPUC. As I communicated with the Secretary earlier today. We are asking the committee to consider continuing this item to the next meeting due to new developments in the case. As we previously explained, Section 85895E of the Government Code does clearly exempt EAPs or emergency action plans from disclosure under the Public Records Act. However, in light of the Moccasin Dam incident last Thursday, March 22nd, PUC has decided to undertake an assessment of whether it would be possible to redact the sensitive information from the plans in order to provide those redacted versions to the public, including Mr. Bussey, without compromising public safety. We just started the review today, and we are in the middle of responding to last week's incident. So we ask if it's possible to continue the item so we can return to the committee next month to provide you with an update. We may, and if we do decide to provide these versions of the EIP to Mr. Bussey before that meeting, we will notify the committee immediately.
I have a few questions, but I would like to ask my fellow member, do you have any questions, Fiona, at this time?
Not at this time, but I might later.
Okay. So how long is the EAP?
Let's see. So the request was for all the EAPs, and they are of different length. They are generally under 100 pages. There are appendices, so
For each dam?
for each dam.
Okay.
Yeah.
And how long do you expect this redaction process to take?
We are thinking it'll take probably we should be able to complete it within 2 weeks. If not sooner.
And what guidelines are you using in order to complete the redactions? I'm just trying to get an idea of
Sure.
what the respondent may receive or
Right.
things like that.
So the bulk of the response plans, the details of how the PUC responds, the actions that are set there, that for the most part will not be redacted, with the exception of personal identifying information or people. There's a notification part, so there's a lot of personal cell phones and that sort of thing. The part that we're looking at redacting has to do with details about the design and engineering of the dams, how it works, how water goes in and out. So we're basing it on several things. One is the Department for the Safety of Dams, DSOD, which is the regulatory division for the state over dams. That also requires us to do the AAPs. Released the inspection reports for Moccasin Dam this week, and they were also redacted. They're short reports, generally between 2 and 4 pages. So we are looking at the way that they redacted, and we would do similar redactions of the details of the design. And in general, we have guidelines about our critical information or critical infrastructure and what we feel is appropriate to provide. So again, the response protocols, who we call, the order in which we do it, who gets evacuated, and what that all is are things that we would be comfortable sharing. It's just within that there's some information
Right.
around the technical
Okay.
specifications that have to be redacted.
Thank you. Do you have any questions?
So, remind me again, why would the parts that need to be redacted, would the technical parts need to be redacted?
So in general, we do not, they are considered security sensitive. So
Okay.
they include specific detail about the construction, design, engineering, and operation of our water system.
Okay.
That is something we don't share with the public.
Okay. Thank you.
Thank you. I would like to give the petitioner a minute to respond to this, I guess, motion for continuing this item. Yes.
It shouldn't take a near crisis and potential loss of human life to force this type of disclosure. This is the decision by the PUC, which I welcome, a redacted release, that they should have engaged with initially. I also take exception to the decision to withhold continually certain aspects of the dam design. If you remember the Oroville crisis, I could have looked at that emergency spillway and said the base needs to have blocks to break the action of the water, and it could be potentially undermined. And the Sierra Club said the same thing in 2009, but the California Department of Water Resources refused to release the problems of the design, and then it took an emergency to get a discussion about that. We need to be proactive, and quite frankly, citizen oversight, lots of eyeballs on our critical infrastructure is what is going to provide that type of safety, because I think that people don't feel safe. Thank you.
Mr. Busey, I have a few questions for you. Do you have any specific responses to the 2-week extension request, for example?
I don't have a problem with the 2-week extension request. I welcome the fact that that they are considering releasing these in a redacted form.
Okay. Thank you. Member Hinsey, I guess my current thought, and I would like to know what you think, is to allow for the extension,
Right.
and that is not going to prejudge what information that Mr. Busey is able to get.
Yeah.
We would have to see at that time what is produced through the redaction and then make an assessment as to if they are in compliance with the ordinance. If he could also let us know if the information was satisfactory to him or not before we move forward on the substance of this matter.
Yeah, I agree. I think that the PUC's argument that they're going to do the redacted versions was fairly convincing, given the circumstances, and I applaud their efforts there. So I think that we should grant the continuance. That said, they anticipate being done within 2 weeks. So I think we can go ahead and probably continue into our next meeting and assume that they should be done by then.
May we continue to the call, and I will do, assuming everything goes well, I will schedule it for the next meeting.
Yeah, I have one more question for Ms. Carroll. So what is the PUC using to designate what is identified as critical infrastructure information?
So we use standards, industry standards, so within water and wastewater, and I don't have them off the top of my head, which we can cite, but in general, anything related to the specific operation of water, potable water, and the Moccasin Dam is a potable water reservoir, so it's a drinking water reservoir. So we have water quality EPA standards, AWWA standards that give us a guide as to what should and can be public.
Well, I'm going to ask you to ask your legal counsel or whoever is advising you on this matter to come up. There should be legal standards for what is being identified as critical infrastructure information. I know at the Federal Energy Regulatory Commission, where they're the ones who do the licensing of hydroelectric facilities.
Right.
In the Federal Power Act, there are specific guidelines for what can be designated as critical infrastructure information. So rather than next time, we're going to be looking for some type of legal designation
Right.
That's guiding your process, not just industry standards or something like that. There should be a legal designation.
So they're actually, believe it or not, for water, we do not have the same regulatory standards as power because we, the PUC, do. I'm very familiar with the power standards, and we have to comply with many of those. So it's a little bit different for water, but I'll certainly bring you what we have.
Thank you.
Yeah.
Do we have a motion at this time?
Sure, I'll move to continue to this item to the call of the chair of the complaint committee.
I'd like to second that. Is there any public comment on that motion? Seeing no public comment, can you call the roll, please?
On that motion, Member Wolf, absent. Member Hensy.
Aye.
Hensy, aye. Chair Tesfa.
Aye.
Tesfa, aye. The motion passes.
Thank you.
Next on the agenda, item number 5, file number 18013, complaint filed by Thomas Bussey against the Office of the City Attorney for allegedly violating Administrative Code Section 67.21I for acting as legal counsel to deny access to a public record.
And before you begin, the respondent in this case is the city attorney's office, correct?
Yes.
Is the city attorney's office present? Great, thank you, because I saw the other folks leave, so I wanted to make sure we had someone for you.
Okay. So I didn't prepare a speech for this one, but the complaint is fairly simple. The city attorney in San Francisco is an elected position. And as an elected position, there is an inherent conflict of interest when the city attorney's office advises regarding certain issues on open government and public records. Is the advice provided by the city attorney in the interest of the city attorney, or in the interest of the public, or in the interest of the person soliciting the advice? And I think that this case shows that in seeing two different memos from the city attorney's office on city attorney office letterhead stating, one, that the task force has jurisdiction, or the other way, that the task force doesn't have jurisdiction, is the cleanest and best example of a conflict of interest I've ever seen. One is ethically separated, the other one is not. And we just heard from the Public Utilities Commission that after I made a request, I was actually interested in what the city attorney was saying about me and about my suspicion about where that $53 million sales tax goes, because I still don't have a record telling me, that there was a communication between the PUC and the city attorney's office. The outcome of that communication was I was given a legal basis by the PUC for refusing to release the dam safety emergency action plans. And it was a fairly thorough legal argument, not the type of argument that you'd normally expect from a communications director. It was the type of argument that you would expect from an attorney. So therefore, circumstantially, it can be inferred the city attorney was solicited for legal advice that the city attorney should not have given, because the city attorney had a conflict of interest and should have recused the office, leaving it to the PUC to make the moral choice whether to release information about their preparations for protecting the public. And that's as simple as it is. The city attorney has a duty to recuse. The city attorney did not, and a significant portion of the Sunshine Ordinance, what was promised to the voters, if you read the Ballot Simplification Committee's argument, was that the city attorney could not give legal advice on this issue. Now, there, of course, is the Sankra decision. And again, this is where the task force's job comes into play. The task force's job is to inform the Board of Supervisors about challenges to implementation of the Sunshine Ordinance. And among those challenges were that the voters were promised a certain thing in terms of standards of conduct, roles and responsibilities of the city attorney's office. That was not delivered due to a court decision that nobody foresaw, and that the Board of Supervisors should consider this. I've seen a memo that was marked confidential by the city attorney's office. There's no it was about putting a land covenant on certain properties so that you had to hire locally. It was complete, and the city attorney said confidentially, "This is an illegal law that you have proposed. Don't pass it." But there's no reason to make that confidential. In fact, the public interest is to let the public know, hey, this law that is being considered is not legal. It's all about protecting the city attorney's elected base in that particular case. So I think that this is a larger issue that the task force is specifically charged to bring up to the public and to the Board of Supervisors that the City Attorney's Office operates without sufficient oversight. And potentially that can lead to problems if the City Attorney engages in affirmative litigation and it backfires. The City is on the hook for a lot of money in legal damages. The City Attorney's Office needs a check and balance, and we don't have it. Thank you.
Thank you. From the respondent?
Hi, my name is Andrea Guzman, and I'm with the City Attorney's Office. Just to clarify, we're responding specifically to Mr. Bussey's complaint about us giving legal advice and being in violation, and not the PUC's ongoing public records request. And essentially what it comes down to is that the City Attorney's Office was performing its charter-mandated duty of providing legal advice to city departments. Essentially, the city charter is the city's supreme law, and it provides that the city attorney serve as a legal counsel to various different departments. Essentially, that allows it to provide advice on a plethora of issues, whether it's on other legal matters or whether it is on legal issues such as public records request. By performing this basic duty that it's mandated to do, it cannot be in violation of the Sunshine Ordinance just because someone disagrees with that advice. Essentially, we're just arguing that the city attorney's office was just doing its job in this situation. And whether Mr. Bussey unfortunately doesn't agree with that advice, it was just performing its duty and it wasn't withholding records itself. It wasn't in violation of the specific Sunshine Ordinance interpretations that he's citing here.
Thank you. And you may be seated. I'd like to state for the record that Member Wolf is present. Do our members have any questions for the petitioner or the complainant?
I have a question for the respondent. Easy question to start. What's your position at the city attorney's office?
Essentially, that we're not in violation of the Sunshine.
What's your person?
Oh, sorry. I'm the deputy city attorney at the. I'm sorry, deputy press secretary at the city attorney's office.
Is that your only question?
For now, yeah.
Okay.
Okay.
I'm sorry, your name again is?
Andrea Guzman.
Okay, Ms. Guzman. Is there a particular statute that exempts you from providing direct advice to a city department or a city staffer in relation to advising them about withholding information?
Not that I'm aware of, unless there's another conflict of interest, but there wasn't any in this situation.
Okay, because the ordinance is very specific on that.
Yeah.
So when the city attorney provides advice, it's meant to be given globally, like with the Good Government Guide and with the annual trainings and things like that.
Yeah. Usually legal advice also falls under attorney-client privilege, which is what we cited also in the St. Croix decision, which we attached fully for your reference. It's quite lengthy, but in case you wanted to read the full decision, that's essentially what the court established, that the city attorney's office is given attorney-client privileges, which would be like in a typical legal advice relationship.
Yeah, we don't dispute that.
Okay.
But we're disputing whether specific advice was given regarding, which would not be considered attorney-client privilege, I wouldn't think, about whether they should withhold, whether they should provide advice on whether to withhold or not. It's purely a question of how does the law work in the city.
We would consider that legal advice simply because, for example, if we were to disclose private information, if we were to advise the PUC to disclose the private home address of a city employee.
But that's not what we're talking about here. We're talking about whether you would, you are advising whether to withhold information or not. You can have maybe a private discussion about what the detail of the information is, but whether there's instruction as to whether to specifically withhold it or not, I think it treads a little close to the edge of what the ordinance specifies.
I think our stance is that the city charter is still the superior law of the city, so even if there was some sort of conflict, that would still remain superior in this situation.
Actually, the Sunshine Ordinance has some has some code written into it that it would overrule if there's a conflict, that the right of for the people to know overrules. So that's why I'm asking if there's any specific, where there's specific citation, if you can present as part, so that we can have a complete record. And because if you're not, the purpose of these hearings is so that the respondent should respond based upon law.
Right.
Specifically, though, cite the statute that gives you the authority to either allow or withhold information, that kind of thing.
I would just point you to the other legal citations that we have in the full letter that goes a little bit more into depth about those.
Okay.
But I'd be happy to, if this continues, to provide more information on those specific issues and citations. Just to clarify, are you seeking citations from the Sunshine Ordinance or?
Well, it's either, so when law enforcement comes in and there's like a pending investigation, they'll cite a section of the penal code that allows withholding of that information.
I think we need to do clarification. So this item has been split up into two.
Okay.
So there's one against the SFPUC, and that's where we're getting into the substance of, which has been continued, the substance of what rationale is being used to not provide, or not provide information about the specific request. Mm-hmm. This has been split out into a separate complaint against the city attorney's office, specifically on 67.21I, on whether they are in violation of 67.21I. And so with that, we need to ask Mr. Busey a few other questions about to substantiate 67.21I. But yeah, Ms. Guzman is not here to speak to what specific sections of the ordinance the PUC is using to not give this information from the earlier complaint that we listened to today.
Thank you, Madam Chair, for that clarification.
Yeah, that's sorry. I was
so with
misunderstanding you earlier.
Yeah, so with 67.21I, if Mr. Busey could approach, I was looking at the packet last night and trying to figure out what evidence or information do you have that the city attorney's office, that anyone requested that they provide advice on how to not provide information. Because that's the issue there. The city attorney's office, all departments can ask the city attorney's office, can I disclose this information? What they're not able to do under 67.21I is ask, how do I get out of disclosing this information? That is what the city attorney's office isn't supposed to be providing legal advice on. So all departments can ask, can I disclose this information? Departments can't be asking, city attorney's office, help me out. How do I not give out this information?
Thank you. And the answer to that is in the PUC's response.
Which
The
page
PUC
are you
says-
on? Which page are you on, Mr. Busey, in the packet?
P310.
Okay, so we're looking at the packet for the other. Okay, P.
There's only
Actually,
one
it's-
packet for both items.
Oh,
even
they've been
though-
combined. Okay, so you
because
said.
they're so integrated in terms of Mr.
That's smart.
Bussey's response.
Okay, so Mr. Busey, do you mind repeating which page are you on again?
Actually, it's P311.
P311.
We're on the
I
second,
don't think I have
second
300
item.
pages.
Yeah. Items
It's
4 and
bait
5.
stamped, so. Right.
I don't have. The last page I have of the packet for items 4 and 5 is P147.
Yeah, that's what I got.
Okay. I don't. have the exact packet for today's meeting because the information was the same.
Maybe you could give me a few words and then I can do a search
Okay.
on here.
It's in my original Gmail back and forth with
Yeah,
the
but I
PUC.
have to look at the packet for today. So give me a few words
Okay.
that I can search, you think.
The PUC does not have any correspondence with the Controller's office concerning anyone with the last name Bussey.
Does not have any, what?
Correspondence.
Okay, I have it. So what I'm looking at here, Member Wolf, Member Hinsey, is on P15.
Right here.
P15.
Yeah, about the middle of the page, it says the SFPUC
Yeah.
does not have any correspondence with the Controller's office concerning anyone with the last name Bussey.
Okay. Okay. The only correspondence the SFPUC has with the City's Attorney's Office is an emailed forward that contains your October 6, 2017 public records request. The correspondence with the City Attorney's Office is considered attorney-client privileged. The City Charter, blah, blah, blah. This charter-mandated attorney-client privilege relationship incorporates the attorney-client privilege, and the Sunshine Ordinance cannot eliminate that privilege. And it cites Saint Croix. As a result, the Sunshine Ordinance does not require disclosure of advice on the city's compliance with public records laws. Therefore, the SFPUC declines to disclose the above subject communication with the City Attorney's Office. From that response of the SFPUC, I inferred that the SFPUC went to the City Attorney and said, hey, we don't want to respond to this Bussey guy.
I mean, that's,
And the City Attorney said, hey, here's the legal mumbo-jumbo that'll get you out of it.
I mean, that is.
And that's what
implying
62.7i seems to
I
preclude.
agree. So that implies too much from this statement. This statement is saying that the PUC was asking the City Attorney's Office how to be in compliance with public records law. That is allowed under all city laws. What this section is saying is that the SFPUC cannot ask the City Attorney's Office, how do we get out of giving this information? So what I need from you is any kind of evidence that you can show that
And
the
that-
SFPUC has asked the City Attorney's Office for ways to avoid being in compliance with the Sunshine Ordinance. Here
Yes,
it's asking
I would
they want to
infer,
be in compliance.
my reading is that getting from a communications officer, my response to the previous page, the SFPUC declines to disclose any emergency action plans.
Sorry, which page are you on? Just is it a little bit before that?
P310, yeah, it's just right before that. Further, it would
What
be
should
a
what should I search? We're trying to just keep up with you.
living rivers.
Living rivers? Okay.
Yeah.
Let me,
And California Water Code Section 6161.
okay, I'll let you know when I'm there. Right now, I'm
So
trying to find
it's
it.
page 12.
Page 12, thank you.
It starts with the Sunshine Ordinances prohibiting invocation, section 6255. Beginning of that paragraph.
Section
Section 20.
6255.
Yeah, that's what I
It starts with section 27.27i prohibits assertion of a CPRA exemption.
No.
That's not the page? Okay. So let's
It's
try-
a Gmail page. It's dated Monday, October 30th.
Yeah, so that's page
Yeah.
14.
but it continues to.
My reading was when the PUC said further, it would be a security risk to disclose these plans. And then it says, see Living Rivers Incorporated versus United States Bureau of Reclamation, 272F, SUP 2D1313. Now, if I am a communications officer, I'm not going to gum up with properly cited case law. Where did that come from? Legal advice. Who do you get legal advice from? A lawyer. Who are the lawyers? The city
Let me
attorney's
clarify
office.
what I'm saying. The PUC can contact the city attorney's office and ask, can I give this information out? And the city attorney's office can say, no, you are not allowed to give out this information. And that's what's going on by giving the citation. The SFPUC cannot ask the city attorney's office, how do I avoid giving this information? So in order to support a complaint under this section of the Sunshine Ordinance, you need to show us when this agency has contacted the city attorney's office and asked for ways to avoid being in compliance.
That's your opinion on on what needs to be shown. That's just one of 3 people or one of every member of the task force. I believe that the circumstantial evidence is sufficient to infer that the SFPUC asked for a way to get out of it, and the city attorney provided the way out initially through the Living Rivers case and then through the subsequent responses of the SFPUC.
So that means that every single time that an agency asks the city attorney's office if they can give out information, and the city attorney's office says no, then they're in violation.
It's not there's a difference between a prohibition and an exemption. If is this prohibited from being given out, is different from, is this exempt from being given out? In other words, a permissive exemption means you can give it out if you want to, or you can decide not to give it out, but it's up to you to decide. And in the case of a prohibition, you say, can I give this out? The response would be, no, the law says you can't give it out. If it's, can I choose not to give it out? Help me on what citation in the law I need to cite, I need to say, and I said, yeah, you have to find this really obscure one in the Emergency Services Act. It refers to this header in Senate Bill 92. That's a different story. That's my reading of the Sunshine Ordinance, and quite frankly, I read the Ballot Simplification Committee's response in Proposition G back in 1999. It said that my understanding of what the roles and responsibilities of the city attorney's office.
So, thank you.
It's
Earlier,
basically-
when the Public Utilities Commission was here, they said that they were going to go through this activity of providing the information to Mr. Busey, but in a redacted format. They needed a few weeks to do that. And when we were asking them questions about what that process would be, I was asking, how are you going to specifically designate this information that you will not be giving out as critical infrastructure? And I explained that there needs to be a legal reason for them to, like, for example, for energy infrastructure, the Federal Power Act says this specific information is considered critical energy infrastructure information and needs to be withheld. And so that's what I was asking them to provide when they come back here with whatever they decide to provide. That is why, in this situation, the city attorney's office has to give a specific case that says this is a reason why you are not allowed to give out this information. I would like to hear from the members right now on what your thoughts are, and also your concerns on going forward. How are we supposed to treat departments consulting the city attorney's office on how to be in compliance with the ordinance, and the city attorney's office saying you can give out this and you cannot give out this? Because it sounds like the city attorney's office is now only allowed to give out information on what they can give out and has to be silent on what they can't give out, when that would be not giving full legal advice on what can happen. So I just want to know, what are some of your thoughts and concerns on the application here, but of course going forward?
So 2 things. One is, years ago when I was on a task force, we had a situation where a case where a homeowner fell upon a big slab of concrete in his backyard that had a manhole on it. Didn't know what it was, but it was on his property, and requested the PUC for information about what that was. Well, finally tracked it down that it was the PUC. PUC came in and declared Homeland Security. Same kind of thing that you were just explaining about the Federal Powers Act. And but they finally said that this was part of water infrastructure, but they were not allowed to disclose, and that they were told that by their legal counsel. Now, PUC is an enterprise agency, and I will ask a question from the city attorney about that, as far as the relationship, because there are certain there's certain staffing that's provided in-house, and because they're somewhat of a independent body, government body, I'm not quite sure, how a lot of this applies. I know Sunshine applies to them, absolutely. I'm not sure how the city attorney's office applies to them relationship-wise. Let me ask that question first. I don't know if you can answer that, Ms. Guzman.
I think I just wanted to clarify that I'm not here to dispute the PUC's complaint. Like, I cannot.
No, I'm not asking that, and I'm not going to delve in that at all.
Right.
We're going to speak only about the actions of the city attorney.
I think, so what we're saying is that by us providing the legal advice to the PUC that they asked for, there's no sunshine violation there because we were just performing our charter mandated
I understand
duties.
that, but I'm going to bring up some other points that you might be interested in regarding that, okay? So my question is do you know what the relationship of the city attorney's office is with the PUC?
Yes, we serve as legal counsel, which would establish an attorney-client relationship.
You provide them with legal counsel?
Yes, legal advice. So there's usually a deputy city attorney that is assigned to
Assigned
a
to
certain
them.
issue.
Okay, very good.
Like generally, of course,
Okay.
different issues would bring
Okay,
up different.
very good. So my second point here is if we go to the actual code of the Sunshine Ordinance 6721I, there's some very interesting information in there, I think, that may help clarify. First of all, it talks about how the city attorney's office has a duty to protect and secure the rights of the people to access of public information at public meetings. So it's a very important point, okay? So that's his first and primary priority, is to do that. Second, it should not act as legal counsel for any city employee or person having custody of any public record for the purposes of denying access to the public, okay? So in an official manner, should not act to in their professional position to help a person deny access. Third, the city attorney may publish legal opinions in response to a request from any person as to whether a record or information is public. And lastly, all communications with the city attorney's office with regards to this ordinance, the Sunshine Ordinance, including petitions, requests for opinion, and opinions shall be public records. So I think one of the questions that we're asking here, and I think what I'm hearing from Mr. Busey, at least in my own interpretation from what I'm hearing and reading, is that he's asking for that communication, the request for the opinion from the PUC to its legal counsel is provided by the city attorney. What did they ask, and what the opinion was?
I think that would be for the PUC to answer if it was a request sent to their department. I think for today, there was no request sent to our office asking for records, and that's...
No, it's not a request for records. It's a request for an opinion. What do you have? An email or a letterhead, a document, a memo from the PUC addressed to the city attorney's office, specifically asking a question?
I am not familiar with that issue just because that wasn't what was brought up today or in the original complaint. So I could not answer if that is attorney-client privilege. If we do have that record, I'm not clear on that.
Is not the complaint, one of the charges in the complaint, 6721I?
Well, and
Are you talking about, are you asked, so the complaint is about giving out advice that is to withhold records.
Right.
The complaint is not about Mr. Busey asking the city attorney's office for information.
Right. So,
yeah, so he has not asked our office for information.
I see.
He is saying that they are violating the Sunshine Ordinance
Or providing legal advice to the PUC.
to withhold information.
Okay, so then, Mr. Busey, let me ask you, thank you, Ms. Guzman. Then what you're presenting here is you're presenting to us that there's an inference
of a violation.
of a violation, but there's no evidence to show that there is.
The evidence is circumstantial by what was asked and what was provided, who was consulted, and the outcome of that consultation. Were they talking about birthday parties? Probably not.
But that's
they
not,
were
but
talking
that's,
about.
But that's not how it works. I mean, we can't just go by he said, she said, and we can't make an inference that somebody did something or not without some form of physical communication.
Which is precluded by the San Qua decision, so we have to go on circumstantial.
How's it precluded?
The San Qua decision was an evidentiary decision. If they gave out advice that they're legally prohibited from giving.
No, that's not what. But that's not what you're asking for, I don't think. I think it sounds like what you're asking for is whether any communication was made between the PUC and the city attorney's office.
I know that a communication was made because the PUC disclosed that.
Asking for information.
Yeah, no, I understand that, but we can't find a violation without some evidence to show that there was a violation. Can't just make an inference and assume that that violation occurred. I mean, it's one thing to say I showed up in an office and I asked the person at the front desk for some documents, and they said, "Well, I don't have them right now. Let me have your email address. I'll send them to you in a couple of days," and then they don't send them. There's a record of them showing up at the office. They can come in and we can, ask some questions about did that person show up? Yes. Were you the one who spoke to them? Yes. That kind of stuff, there's evidence there because there's testimony.
Well, the PUC's response is testimony. The PUC said there was a communication and we refused to give you this communication. So that, and the input to that communication is known, the outcome of that communication is known, and there is also a prior issue that I've had with the city attorney's office, which is Mayor Frank Jordan in 1993 asked the city attorney office to make a public legal memo that the city attorney's office refused to respond to me. I know that the memo exists. It is a statement of city policy. The city attorney office, we don't know anything, is about an ongoing special district called the Public Finance Authority. So when my name comes up in a new communication from the SFPUC, hey, this Bussy guy who's got a really weird name that people remember, city attorney's office goes, oh no, not him again. We're going to find a way to stonewall him. That's my impression. And I'm sorry that I get that impression, but that type of impression comes out of the very lack of transparency and the structural problems that I have discussed in regard to the city attorney's office.
I think what we need here would be, as Member Wolf has shown in 67.21I, you are able to obtain information about what kind of advice is being given regarding compliance with the Sunshine Ordinance. If you ask for those documents and there is a record saying the SFPUC asked the city attorney for how to avoid being in compliance with the Sunshine Ordinance, that's where the violation of 67.21I takes place. Right now, the evidence that you have shown us has shown that the SFPUC asked the city attorney's office about how they could be in compliance with the Sunshine Ordinance, and they have, and the advice that was given was, you can't give out this information, you can give out this information, and that's what's allowed to happen. But departments are not, the city attorney's office is not able to help people avoid being in compliance. If being in compliance includes we can't give out, sometimes not giving out information is in compliance with the Sunshine Ordinance. There are reasons why you're not allowed to give out information. And so I think that that right now all I see is an assumption that advice from the city attorney's office saying that something wasn't able to be given out was in response to a request to do something illegal, to a request on how do I avoid giving out information? How do I avoid being in compliance? When what you've shown us is information that was sought on how to be in compliance.
I read it the other way.
I would just add the other thing is if you asked if the respondent, San Francisco Public Utilities Commission, is not willing to give you their communications to the city attorney's office, and they are citing attorney-client privilege, that's their right. But the Sunshine Ordinance commands the city attorney's office to provide all communications with regards to requests for opinions and those opinions that are the response to that request.
So it sounds like you're asking me to make a request of the city attorney's office for the communication from the SFPUC.
I'm not asking you. I'm just saying that you're asking for a violation of 6721I. This only applies to the city attorney's office. It does not apply to the PUC.
And you are able to request this information from the city attorney's office pursuant to section 67.21I, where it says that all communications with the city attorney's office with regard to the Sunshine Ordinance, including petitions, requests for opinion, and opinions shall be public records. Now, if you file that request and they refuse to give you information, then there could be a violation of 67.21I. If you file that request and you receive information stating that the city attorney's office provided advice to the SFPUC, where the SFPUC is requesting information on how to not be in compliance, how to deny public records, then that would also be a violation on behalf of the city attorney under 67.21I. But right now, we don't have, the purpose of this committee is to make sure that all of the pieces of evidence to support a claim, for example, here under 67.21I, are present in the packet before the full task force takes on this issue. Right now, we do not have that critical piece of evidence that would support a violation under 67.21I. Right now, we do not have any direct evidence that the city attorney's office gave advice to the SFPUC pursuant to a request to avoid compliance with the Sunshine Ordinance.
First of all, the direct evidence is precluded by the Qua decision, so it's kind of pointless asking for it. Second of all, a case can be circumstantial. That's the other type of evidence that there is. And the totality of the circumstances indicate, according to me, and you may have a different opinion and you may have a finding that is different than my perception, that a violation did occur.
I guess the reason I find that difficult is because any department that asks the city attorney's office for advice is going to get both kinds of advice. They're going to say you can disclose these, you can't disclose these. And I'm concerned that allowing this to go forward on this kind of circumstantial evidence would be that in any case where the individual did not receive some part of the information, there's an assumption that the city attorney's office was in violation.
I think the means for what this is meant for is if the city attorney was complicit in trying to prevent public information from being disclosed. The first thing the city attorney's office has to do is, as it says in 6721I, is that it needs to present to the public that the information is public. And if the information is public, fine, it's all public. If there are other statutes or case law that prevents any part of that information from being withheld, or all of it from being withheld completely beyond redaction, then providing that advice would be, it should be noted as public advice. It's not private advice. And that's why that last sentence is there, that the opinions shall be made public. Okay, and that way everybody benefits from it. Okay, but we have to be able to see that something other than that actually happened, right? And that's something it's hard to take it on inference. Again, I can cite another case. This was a case against the again, it was against the Public Utilities Commission with regards to a power plant that the city had gotten as gift. And it was being stored in Texas somewhere. And there was plans to have it installed in San Francisco. And the PUC was asked about information about it and whether they had communications with the California ISO. And the PUC declared, the director of the PUC declared at the microphone here that they had received no information. They had no conversation with them at all. And then the complainant presented evidence of emails that were provided by Cal ISO of those communications. Okay, so that's an important factor. But to say that, well, there had to be some discussion between the two, yes, there probably and could be, and actually under 6721. If we find that information is public and that it would appear that there would be evidence or something like that, we could, and if they were withholding it, we can compel them to do it. It's our only authority to do that if we find that the information is public. Now, here the question is does the PUC have rights under attorney-client privilege not to disclose certain information, and which information can it withhold? But we're talking about the other side of it, the attorney side of it. And so here I would only say that if it was asked and not given, right? That's otherwise an inference that there must have been something happening. I would say somebody needs to go and find that information to find out if that happened or not. And if that information is available. I don't think that treads on the St. Croix case at all. The St. Croix case, I believe, deals more with the details of the actual case itself and those communications versus whether did a request, and if a request did come, that should be public. And if an opinion was given based upon that request, then that should be public for the benefit of the public. That's kind of where I'm standing on this. So,
Member Hinsey, do you have any comments or motion at this time?
No.
At this time, I don't have a motion. I don't see how we can allow this item to move forward without that critical piece of evidence.
right. I would also note for the record that Section 6736, which cites that the ordinance supersedes other local laws. It also cites that whenever a conflict of local law is identified, the requirement which would result in greater or more expedited public access to the public information shall apply. So unless that's been challenged somewhere, it's not notated in our memorandum from our legal counsel of any of that. So I don't know whether we need to ask any other further questions. I don't know whether it's the St. Croix case is not also, it's not cited in our memorandum either that I scanned through it. So I don't know if we want to ask legal counsel in preparation.
I mean,
or do you want to continue?
I don't
this,
really
or?
see
Would you
anything
like-
in
yeah,
preparation. I
you-
think we need that piece of evidence,
Okay.
that fact, in order to have this item move forward in any way.
Okay.
So.
I'll move to continue this item. Just call the chair.
Well, I mean, I don't know if we can,
Uh,
I don't know what we would be continuing exactly. We need, a whole new request needs to be put in. And, I mean, the request could come back with the information that shows that this is not supported, 67.27, but I don't think that the complainant is precluded from doing that. Right now, it's up to him to seek out that information. If he finds that information, he can file a complaint to support that information.
Okay. Let me just ask Mr. Bussey a question. Your complaint as filed with us is for two things. One is failing to adequately respond to a records request, and two, acting as legal counsel to deny access to public records. Is that correct?
Yes.
Okay. So the discussion we're having is really on the second part.
Which page are you on?
I'm reading 107. I'm reading from our legal counsel memorandum. So on the first part, now I may have come after that discussion had already taken place. So I'm wondering if that first part, had you already exhausted discussion on that part?
You're on page 107?
107.
Okay, let me get there and see. And under which section are you?
It's just under complaint, the very first paragraph. It says the,
So we are dealing with, the first part has been continued.
okay.
The PUC believes that, to the call of the chair, the PUC believes that it needs about 2 weeks to redact whatever should be redacted and provide the information.
So that doesn't apply to the city attorney's office?
It does not apply to the city
Okay.
attorney's
Okay.
office.
I just wanted to
Yep.
be clear on
I
that.
mean, they could be consulting the city attorney's office to figure out what needs to be redacted.
I
So I
understand.
did ask them, they said they would redact it according to industry standards, and I said there needs to be a legal standard for this information to be redacted.
Okay. Thank you.
Seeing no motion,
No, she made a motion.
well, she took back her motion.
Okay.
Do we have any other motions at this time? Move to the next item. Oh, well, public comment would be on a motion.
Just a procedural question. If there's no motion, what is to become of this matter?
I mean, I think the matter is closed. The petitioner, I don't want to say it's closed because that would require a motion as well, but
In essence, if we do continue to the call and if we don't reschedule it, it just sits there in
In limbo. No, I'm
okay.
not.
Well, then I would like to make a motion to dismiss this item without prejudice.
And we need to refer that up to the full task force for a final decision.
Oh, right.
Okay.
Okay, I believe the motion will be referred to the full task force with the recommendation to dismiss the matter without prejudice? Or to find that there was...
What, can you explain to me what you mean by without prejudice?
I mean, I would like Mr. Busey to be able to bring this complaint back if he asks for information and doesn't get it from the city attorney, because we've outlined a couple of things of ways where information, he should be able to receive information from the city attorney on this
Okay.
matter, so.
I'll second that.
Do we have public comment on this motion?
This is a difficult one because city attorney opinions are kind of rare. They're expensive to write. They take a lot of time. And if every department who probably by phone had a short conversation with someone in a city attorney's office, if they were required to write an opinion, that would be a big thing. And most probably an opinion doesn't exist unless it's on a very big matter. So I think there have been 2 of these such violations that have issued against the city attorney's office in the past. And I did look at them, but they had the evidence that was requested. It wasn't by inference, it wasn't by a previous example or a court case that wasn't really on point. So it's the type of thing where the person who makes the request has to be very focused in the wording, what he wants, how he wants it, and more importantly, when he files a complaint here, it has to be very specific along with the codes that pertain to what he wants. It's not an easy thing. It's very difficult.
Thank you. Do we have any other public comment on this motion? Seeing none, please call the roll.
On that motion, Member Wolf.
Aye.
Wolf, aye. Member Hensy.
Aye.
Hensy, aye. Chair Tesfa.
Aye.
Tesfa, aye. The motion passes.
Can we take a 5-minute break?
Back on the record.
Thank you.
I'm reading the St. Croix case.
Next on the agenda. File item number 6, file number 18009, complaint filed by Antrabo against Dwight Moore in the Office of the City Attorney for allegedly violating Administrative Code, Section 67.21, 67.26, 67.29.5, and 67.34 by willfully failing to respond to immediate disclosure request.
On page 154, 155, and 156 of your packet, I gave a narrative. Basically, this is the second time this investigator did basically the same thing. The first order of determination is here, and they state that there were no responsive records. That's 158 of your packet. So here, the response, I don't know what happened to John Cote. This woman has been around for a while. I recall speaking to her probably a year ago. She says there are no investigative notes. Are there investigative notes or are there not? We don't know because they're two different responses. So I would kind of question how they go about their searches or that kind of thing. So, of course, it's a late response. I didn't get any response until I filed the complaint, and the original one was on February 22nd, which is quite a while away. So that's 6725A through D. There was no 10-day extension. The documents weren't sent on a rolling basis. 6721.9 is because there's a presumption that the record sought is public. The case is over. It's done with. And the burden is on the custodian of records to prove what exemptions apply, and the exemptions that they cited don't apply. And I gave reasons for them, page 154 and 155. Dwight Moore is a civil investigator, not criminal. He's not a lawyer. This was a civil appeal, not criminal. And I even included Article 2 of Government Code 6276.04, and cited a case that was right on point. So that was that. Once again, Dwight Moore is not a lawyer, so that exemption doesn't apply. Withholding kept to a minimum. They supplied me with the underlying court transcript, which I didn't ask for, and a docket. I don't know what you call it here in California, of the underlying case. So the justification of withholding, the custodian shall inform the requester of the nature and extent of non-exempt information and suggest alternative sources for the information requested. That didn't happen. There was no alternative sources. And the problem I have, as with most everything in the city attorney's office, you don't get Dwight Moore in here. To this day, I don't know what this man looks like. It's passed through so many different people and so many different versions of things that it leaves me wondering really what is going on. Basically, what happened here is they just issued a generic response and didn't bother, most likely, to find out what was going on. So I included the sections in the packet that I thought applied. And as we all know, any civil servant in San Francisco is responsible to accept and process a IDR, especially Dwight Moore obviously knew what it was since he was found in violation previously. What else can I say? Do they have investigative notes? I rather doubt it because I did a public record search. I sought him out, and what we were talking about had nothing to do with this case. That's it.
Do we have anyone present on behalf of the respondent?
Once again, my name is Andrea Guzman, and I'm here with the City Attorney's Office. I just wanted to clarify that I'm responding to Ms. Trabeau's original complaint about the timeliness of the request. She has not communicated with us directly about the investigative notes that are exempt from disclosure, so she could communicate directly with us, and we could address those concerns if she has them. It wasn't.
Before you begin, I saw in your email, in your response to her, that you are not providing the notes because of
Yes.
attorney-client privilege.
Yes.
So you should be addressing why you believe attorney-client privilege applies to an investigator's notes.
Because they were for a legal matter.
I mean, that should be part of your presentation.
Yeah, I'm sorry. It's just that the original complaint didn't address those issues, so that's why our original response, the letter, doesn't address it. Just wanted to clarify that.
On what page is that letter?
That's page 218.
So our response was sent March 14th, 2018. But to continue, we were unfortunately unaware of Ms. Trabeau's request until it was, we were notified about it through her complaint with the task force. Mr. Dwight Moore was out of the office when he received it. He dismissed it. That's not an excuse. He should have forwarded it to the people who work on public records request. As soon as we found out about it, we tried to reply as soon as possible to Ms. Trabeau's request. Like, again, we apologize for the delay. We would just ask her in the future to send it to the public records request email address just so we can have those centralized. We have spoken to the investigator about to immediately notify others in the office when he receives these requests so we don't have this issue again.
I have a question, Ms. Guzman. So on page 218, which is your response, it says in the first paragraph, her request asked for, quote, all investigative notes, transcripts, and copies of police reports concerning California Court of Appeals case A145945 and Trabeau versus City and County of San Francisco, unquote. Can you comment on that? Whether those documents were provided?
So we did provide her the transcripts that we had. The only other responsive records that we did have were investigative notes, which we said were exempt from disclosure given attorney-client privilege.
And I have another follow-up question to that. So in her original complaint, it references 67.26, which is withholding kept to a minimum. So that is the section, you should have been responding to that section. She's saying that withholding should have been kept for a minimum and they withheld all of the investigator notes. So I'm not sure, unless you're speaking of something else. You said you weren't aware of her complaint on what matter?
I'm sorry, I was under the impression that her complaint was specifically was found a violation of timeliness.
But it says 67.26 on it.
Unfortunately, we just must have missed that. But we would cite that it was attorney-client privilege.
Okay. I just wanted to make that clear. On page 150 of the packet, you can see
And we apologize for not expanding on that in our original response.
Okay.
We can provide further information.
I'll allow you to give your presentation, then maybe we can ask questions after that.
I mean, that's essentially we were late, we apologize, and we try to get these records as quickly as possible to Ms. Trudeau. We just would ask her to send it to this other email address just to centralize this request, and we can hopefully get.
I don't know if that would be necessary because it would still be within this complaint. Just because they failed to address it doesn't mean that it wasn't already included in her complaint. 67.26 is listed on the complaint.
Right.
And
they responded to it.
And the
in
response is that it's attorney-client privilege.
Right.
So, or attorney work.
Oh, sorry,
product.
I don't-
Attorney
yeah.
work product. Okay.
They say attorney-client privilege and attorney work product privilege, and gave a reference to California Evidence Code, California Government Code, and the Code of Civil Procedure.
Essentially, we should have done better in this situation, and we apologize to Ms. Trudeau for not getting those to her in a timely manner.
Okay, but your response at this time is still that you will not provide the investigator's notes because you find them an exemption under attorney work product.
That is correct.
Okay, so I guess right now we have to have a discussion over whether we agree that work product privilege applies to third-party private investigators. So usually those notes need to be specific to discussing strategy of the case. Asking, if the attorney is asking the investigator to, can he look for this? Can he find that? That is about strategy of the case. That's attorney work product. But unless it's that, I don't see how how a third-party investigator can have attorney work product apply to their notes.
To clarify, Mr. Dwight Moore was performing work on behalf of the city attorney's office, specifically for an attorney working on the case cited here.
Okay.
Yeah, and I'm not. I'm looking for our legal counsel's memorandum. I see one on page 213, 213. I thought I saw another one, but this involves the city attorney's letterhead, so sometimes it's hard. I've got to make sure I'm reading the right thing, because there's not much information in there regarding this particular question. Well, I mean, he didn't mention anything about 6726.
If I may, I found this memo slightly.
If you're going to speak, please wait for the chair to acknowledge you and speak into the mic.
Covers the waste proposed on timeliness, covers exemptions and disclosure. So he's citing the CPRA here. Doesn't really give any
I feel like
advice.
pages might be missing from the memo.
Think so?
Well, I mean, on page
At the bottom background?
on page 213, he does make reference to 6254 governs exemptions.
Right.
But then I don't see any kind of analysis from him on 6254.
Well, right below that, it says on February 1st, under background, request all investigative notes, transcripts, copies of police reports concerning California Court of Appeals case, so on. And then on the next page, page 214 at the top, it says on February 20th, 2018, after alleging not having received a response complaint, filed a case.
I mean, under legal issues, legal determination, a question that should be there is, do the exemptions governing, do the 6254 that governs exemptions to disclosure apply to this case?
Right, and apply to the citations that the city attorney's office provided. Does the Sunshine Ordinance have any overreach?
Overreach, but then also how far can attorney work product apply to a
Right.
third-party investigator? I mean, in my experience, it's usually if the investigator is asking for advice or is discussing the strategy of the case with the attorney. The attorney is saying, you need to find this, this, and this for us in order for us to support this legal argument.
Right.
but it would be good if that was in the memo.
So for the, yeah, right, I think we should request that to be in the memo. I think it's important for those of us not attorneys to have a clear understanding what that is. Yeah, and for the public, yeah. The question is whether this case should be continued till we get that information, so that if we're going to, because we're going to continue to, if we continue to ask for those investigative notes, that advice would be helpful.
Yeah, I think that this item can move forward because we have all of the facts. We have all of the facts. Ms. Trudeau has asked for the information, and they have said in writing that they will not release the information because of attorney work product.
Yeah, fair enough. But I think we should ask our legal counsel to expand on that question.
May I get a simplified version of that question that I can send to DC Acola?
Yeah, so for him to provide legal analysis as to the applicability of the exemptions for attorney work product to the requested investigative notes.
For a person of this position?
The investigative notes from an investigator.
Right.
Thank you.
Do we have any motions at this time?
So I move that we find this is within our jurisdiction, that the information is public, and that we send this to the task force and provide instruction or directive to our legal counsel with that question.
Second.
Do we have any public comment on that motion? See no public comment. Can you call the roll, please?
On that motion, Member Hensy.
Aye.
Hensy, aye. Member Wolf.
Aye.
Wolf, aye. Chair Tesfa.
Aye.
Tesfa, aye. The motion passes.
And as we move forward, I would recommend that the city attorney's office do some legwork on find some specificity on why you would believe that the attorney work product exemption should specifically apply to these investigative notes. That would include some generalities as to what's included in the investigative notes that make it that actually attach attorney work product to this investigator who's not the attorney.
Yeah,
We need those details.
Yeah, we've had this question before because people will come in and cite something, but then not qualify it. So, okay. Yeah, that'd be great.
I would also ask that they give details on their search techniques, because in the previous order, page 158, they say quite clearly they don't have investigative notes, and now they're saying they do have investigative notes. So what search criteria did they use?
I thought they were saying they don't have investigative notes to the docket number that you gave that was incorrect. That's where they don't have any information, but for when they corrected the docket number?
No. This is a previous order that issued against the same person for almost the same thing.
Okay. Well, at this time in writing, they have stated to us that they do have the documents, but that they are not releasing them because of attorney work product. So we are going to be allowing this item to proceed with these documents exist, and we're going to figure out if we can get them to you or not.
Yeah, because it was a waste of about $20,000 of taxpayer money. There was no police report, and you can see there was no referral made. Anyone looking at the transcript would have just
I would caution that we are not here to review their Board of Appeals case. We're only here to review the Sunshine Ordinance Task Force
Had they
issue.
done a correct search, this case...
Thank you. Can we move to the next item, clerk?
Next on the agenda, item number 7, file number 18010, complaint filed by Denta Detessa against the Office of the City Attorney for allegedly violating Administrative Code, Chapter 27, by violating the right to privacy. I would just like to note that I have not, the complainant is not in the room, and he has not provided any information regarding his absence at today's meeting. It is our standard policy to table and conclude the matters and to send notices to the complainant, notifying him of the action and giving him the opportunity to reopen the complaint if he has a valid reason for not appearing.
We have a motion to take that action.
Sure, I'll motion to table the item.
Second.
Do you have any public comment on that motion?
Having listened to previous cases surrounding this issue, he made almost the identical mistake that I made. Because he didn't know it at the time, he was improperly served. He took it upon himself as a citizen to contact the city attorney's office to try and find out what was going on. And that just complicated issues. When you're not represented and you see a document on a letterhead and the envelope happens to be open and it becomes an event, you learn from your mistakes, but I wish he had been here today. I would have explained it to him to just remain silent sometimes.
Thank you. Any other public comment on that motion? Seeing none.
On that motion, Member Wolf.
Aye.
Wolf, aye. Member Hinsey.
Aye.
Hinsey, aye. Chair Tesfa.
Thank you. Aye.
Aye. The motion passes. Give me one moment, please. Next on the agenda is item number 8, file number 18015, Administrator's Report, Review of the Next Request Public Records Request Software. Just for your information, I did inform you that I would experiment with the website, and on 3/9, I submitted a public records request to the Arts Commission via Next Request, their online version. I received an email requesting or asking that I open an account. Basically, they required that I open an account once I submitted a request. That first email I received was received within minutes of the request being sent, and it was titled, "Your first records request 18-637 has been opened." And then a few minutes later at 12:45, I received a second email stating, "Action required, your San Francisco Public Records portal account." And it requested that I go in there, put in a password, and actually create an account. Regarding my observations, is it really required that I open an account? I believe that has been asked of many members of the public and the task force. Why do I have to open an account? And just based on the use of that initial first page, you do need some technical or general software aptitude to be able to get through it. It's not an easy-to-use website. And confirmation of receipt, I did receive another email. Email titled, "External Message Added, San Francisco Public Records Request 18637. And I would like to note in this email, there was information regarding the 14-day extension. I believe it is a template, from the looks of it, it was a template language from Next Request and not from the Arts Commission itself. I believe it may be a checkbox or something where the Arts Commission will say, "I need more time," and click this, and we'll send a message saying, "Extension requested." I asked Arts Commission to do this on purpose just so I could see what would happen.
Got it. You have a question?
Yeah, I have a question.
Yes.
So, with regards to the issues that we have brought up around why does an account need to be created?
Yes.
What if somebody wanted to make an anonymous request? If somebody wanted to make an anonymous request, I mean, how would they then do that through the Next Request system? And also, when there's no requirement to provide any identification, you come into a public meeting, there's no required to sign in or anything like that.
My best guess is you can create it doesn't ask for your name, or if it does ask for your name, you don't have to provide it.
Right.
And you would need to create a third-party email address to use the system. And my question itself is, what if I don't want to use the system? And this is something we should ask one of the departments.
Well, yeah, I mean, the There's no, there's the ordinance doesn't make a requirement for this. It could still be done in this verbally or in the standard written form that everybody does it now. The other thing is why anybody has to provide an email address at all. If you go in and you have you file a request and you're given, let's say, a URL, you must keep, that URL or an ID number. You can then, it's like a tracking number for when you buy something online, you want to track it at FedEx. They can just give you a number.
That was my experience in that
Okay.
when they tried to forward me the response via Nix request, I couldn't open it myself because I don't have access.
Oh,
But when I open the account and I get that email, I can open it.
So which I
So
think
you have to then have an account to
Well, I
access your
believe if
response.
it's your request, very easy to open. The email they sent me listed all the public works requests for various departments, and it wasn't specific to that one request. Basically, all the public works requests appear to be maintained and available for viewing.
Yeah, because the purpose of that is so that, if I want something and it's already been released to someone else, then I can just find it on there. I don't have
Right.
to submit a request.
But I didn't find an easy way to search through it.
Right. And I was to understand that in other counties or municipalities that it's not private.
It's not private. Well, so the back and forth on the progress of your request is private. But then once the document has been published, like they found the document, they found that it
Right.
can be published, it'll be available online through this like index, so that if someone else is looking for the same information, they don't have to put in a request, wait 5 days, wait whatever number of days. And so it's supposed to save the user time, where if something's already been disclosed, it's already available to them. And then it's supposed to save the agency time so that they don't have to look through the documents, look for what exemptions are. If redaction has to happen, getting an attorney to redact it, the redacted or whatever version of it will already be available.
But isn't the actual process itself public anyway?
If someone wants to request the information, sure.
So if I made a request of Rec and Park Department and in the middle of the process, somebody else, my friend says, hey, I want to know where they're at in the
Yeah,
process.
that's public.
Right.
You can request that information.
But on next request, you can't. That part's private. on
Well,
next
it's private
request.
to you, but if someone else wants to ask, did Bruce Wolf file a request, then they can give them that information through next request.
How would they give that if I'm confused? So
Well,
if,
they do have a list of all the public records requests that you can open, but it's not organized in any specific means that I can.
no, but if I open a request, then the process is private to me only.
Well, if someone makes a request for that information, that's public information, but someone would have to request that information.
So they would open up another next request.
Right, but I'm just saying that it's like all of the information isn't just all out there. It might be public information that someone can request and get. That's for
But
all city information.
Yeah, I
but
get
it's not
that.
just all online.
I guess what I've heard from other people in other municipalities is that the process itself, once somebody enters in a request, that is open for the public to watch and see the progress.
I haven't seen that on Next Request.
No, because it's not been published.
Yeah.
Please wait to be recognized.
So, Victor, I have a couple questions.
Mind if I just
Yeah.
Finish
just
your
go through a
report.
few
Yeah.
more
Go ahead.
points?
Yeah.
I did receive a response. The title of the email was document release and the file number. In that email, it does provide a list of documents that were released that are links. I did request the audio recording, and when I initially clicked on that audio recording, it did not work until I logged into the Nix request system. So until I log in, that audio recording was not available to me. And then in terms of documents, it opens up a web page with PDFs of the actual documents. So that is something questionable. And why do I have to log in to view my documents?
Right. And the other question I have is whether those documents are searchable and
I
will
did not
reveal-
test that.
reveal the metadata.
Yeah, because you should be able to see like what requests have been put in. and what requests are being worked on. Like every little response that you're getting via email, that might be, just not out there, but you should be able to see like this request was put in on this date, and what's going on with it.
And then just to skip through, after that, I did receive a second email, an additional email stating that the notice of request had been closed because basically they stated that they filled my request and the request has been closed. And I would like to make an observation that when you do log in to your account, you have the option of setting how many emails you receive or status updates. You can receive all the status updates, and you can be very selective about what you receive. So, there have been issues with people stating they are getting too many emails regarding a single request. There is the possibility that they can go in and change their settings so that they only receive relevant emails. And I believe I received 4 to 5 emails regarding this single public records request.
Okay. I noticed that you highlighted the download icon.
It didn't seem very obvious to me.
Yeah, it's not. It's poorly formatted. It's so far away from the. Yeah.
On the San Francisco Arts Commission website, where do you go to file a request?
I will get the link to that page and forward it to the members.
Do you have any idea of what it's called or anything like that?
I believe if you just type in public records request, it should provide some link to it.
Not Sunshine?
Go to the SFAC,
AC.
and then in their search field, just type public records request.
Yeah, but that's not appropriate either. Let's see, public meetings. Yeah, because at the bottom,
It's not obvious none of the city's websites are obvious on the very cover page or the initial page where to find out how to make a public records request.
So this is similar to the one that I've used. So at the top, so when you hit the red button.
Oh, here it is.
Yeah,
It's on the contact
Yeah,
page.
and not that part. But see at the top where it says all requests?
Yeah.
So if you click there, that's where you're able to see an index of all of the requests that have been submitted and the status of them, if they've already been responded to and stuff like that. You don't have maybe every single back and forth that the individual user has, but you know that, it's been sent to legal or it's been whatever. It's been fulfilled or it's still open. It's been closed. What was the assignment, stuff like that. So anyway, thank you so much for that report. Do we want to ask Victor to continue this process, or if there's any follow-up, do we want to have a report given to the full task force to see if we want to make any recommendations to?
I think it would be good to know whether this has been deployed everywhere. And
Not all departments. I believe there's select departments that are using this.
okay. So I think an ongoing status report would be good, and also the question of anonymous. How do people who want to make an anonymous request work?
That may be the case.
Anonymous, and how to use it without actually
Right.
opening a file or
Right. I mean, if you
logging in.
if you're given a request number, like I said, if it's like tracking a package. If you're given a request number, you should be able to enter that into a search function and be able to find it, in that kind of way, and be able to see what's happening. I mean,
I think the next request system has been, it's a proprietary thing that someone else created and different agencies are putting together. But if there is some type of city response as to, we still have these ways for people to submit things anonymously, things like that. But we're not going to be able to say we need to move the download button around, redesign that, because that's not.
Well, we can make a request of it, whether it'll be honored or not is a different thing.
I think we did have a representative attend one of our meetings. Maybe if we can consolidate our questions. We can probably have her return.
Because
with
this looks
update.
exactly like the same one that's used at my work.
So the thing, though, is that this is under a city contract. If something is not working, I'm sure they have provisions in the contract for alterations.
And I'd like to also point out that I believe that they list the 14-day extension as an automatic language from the California code, and
not
they
the
don't
10
do
day.
10 days. And I don't
That's
know.
what you're pointing out. Okay.
That's an
So
important.
do we want Victor to make a presentation at the full task force at some point, and then we can decide if we want, the full task force can decide if we, like, what kind of action we can take, what kind of follow-up, what kind of advising we might want to do on the matter?
I think that would be to have Victor do a presentation to the full body would be a good thing.
At the next meeting, or do we want to wait a certain period, have him do more research? What do you guys? I'm
what do
open
you-
to anything.
How much time do you
Oh, yeah.
think you need?
I'm just not sure what else I can find. I've gone through the process once. I can consolidate our questions.
Okay.
But in terms, maybe a meeting with the representative from Nick's request would be the next.
Yeah.
I don't know if you want to do that at the committee level or.
Well, first we'd have to have you do the report for the full task force, I think. Because I think
Yeah.
that they'll have some knowledge or experience or information to share with you like we have. When do you think you would be available?
Not the next meeting. I would need additional time.
Okay,
So maybe the meeting in May.
okay. What do you guys
Okay,
think of that?
That sounds good.
Do we have a motion on that?
Do we need a motion, Victor?
I don't. I guess we can refer this to the full task force.
Yeah, sure. So I'll make a motion to refer to the full task force with the recommendation that Victor present his findings from his experiential research to the full task force.
I'll second.
Do we have a public comment on that motion?
Yes, there's several things that are not correct. Firstly, I expressly made a document request asking where does the 14-day extension come from. It's not generically generated from this next request system. It came from Kate Patterson. Secondly, the reason why you have a backlog, mainly of my complaints, is for this very same thing, because of the overabundance of emails that I get that are not on task, they're not on target, they're not documents that I requested, and they're not published. So if they're not published, they're not available to the public or available to me. So that is a big problem. The communications that Victor Young got were very different from the communications I got. If I open a request, there's no back and forth, there's no help on the part of anyone from the Arts Commission. Well, this is how you download the audio, and these are the steps that you need to go through. Absolutely not. I've gone out of my way to go to that house on Brannan Street, which is the address listed on the next request, several times, knocked on the door, and there's been no response. There's been mail that's been piled up. I've left phone messages, never received a response. Once I got a woman on the phone who didn't even know how to use the next request system, and that was the number listed on their website. So the research that Victor Young did is different because he was treated differently because he's the clerk, and Kate Patterson treated him completely differently. He was not bombarded with 2,000 emails. His thing saying a person needed a bit of technical expertise is an understatement. There are people that want to know documents, they want to be able to pull it up, and of the other city departments that are using this system, the people that are using it know what they're doing, and you're able to access that information right away. There's not these extended, long things where you have no idea what's going on. And to open the same request 3 and 4 times because you didn't get the documents you wanted or you got over 2,000 pages is a waste of everybody's time.
I just like to say that I did not receive any advice from any third parties. I figured it out on my own, but it was difficult to work around. I did have to hunt and peck a little bit and experiment before I can get it to work correctly.
Thanks for that.
So I just two things. One is that I think you should explain that during your presentation of how maybe not user friendly or not user friendly enough it is, that it does take a little savvy to do it. The other thing is on page 245. I was hoping Ms. Trudeau would still be here, but it does say at the bottom, please note the above is a template with options inserted from the next request system. So what the parts that are options that are inserted are preceded with a hyphen. The parts that are part of the template are not preceded with a hyphen, and the 14-day extension is part of that template.
It's wrong, but it is
Wrong.
part of the template.
It's part of the template. So whoever either created the template, whether it's part of the developers that developed the system, if it's all in California, and there's no sunshine ordinance in a certain city, then it's going to be 14 days under the CPRA. But in San Francisco, that needs to be changed. So to 10 days.
And in regards to the history of an item, if you do log in and click on the complaint, it does give you a history of every email sent out regarding that complaint. So if somebody says that I received 200 emails regarding this, it will be listed under that complaint number.
I see.
And you know what's interesting is it cites 6721B with regards to that 14-day extension, and it says in 6721B that the information shall be provided a response should be provided in writing as soon as possible and within 10 days following the receipt of request that the record in question is exempt. I mean, it's actually not the right, or it says at the beginning, as soon as possible within 10 days following the receipt of the public record to comply with the request. So it actually says 10 days in there.
Yeah, that's
And
what he
there
was
was
pointing
some
out.
confusion in
Yeah.
the past, not that we apply it now currently, that an excuse could be that they included weekends or not.
It's calendar days.
Yes, I understand that, but that was one of the past,
But that's been the case for posting of agendas.
yes.
Is 3 days in advance, including if you post it on Friday, does that include Saturday and Sunday? That's
So,
always.
our current interpretation is that weekends are included for everything.
Right.
Great. Well, we have a motion on the table.
Yeah.
Can we call the roll on that?
On that motion to refer the matter to the full task force for reporting, Member Wolf.
Aye.
Wolf, aye. Member Hinsey.
Aye.
Hinsey, aye. Chair Tesfa.
Aye.
Tesfa, aye. The motion passes.
Thank you for your work on that.
Next on the agenda is item 9, announcements, comments, questions, and future agenda items.
I don't have any announcements, just reminders for everyone to do their ethics training, Form 700 for Victor.
Yeah.
And there being no further business?
I just wanted to ask regarding that. Did we get sent this time around the password for submitting the Form 700 online?
No, I had
no.
to use my password that I've been using since I created the
Okay, I'll
account.
Yeah, the old
Dig up
password.
the old
yeah,
one.
Yeah,
we
the
can do a reminder, or they'll send you a thing in the email.
You'll have to
I
dig
didn't
it
get a
in.
reminder.
No, you can say I lost my password, and
Oh,
then
I
they'll send
see.
you like a password reminder
Got
or
it.
something like that.
Got it.
Yeah.
Okay, very good.
Or you'll have to dig it up like me.
Thank you.
Okay.
Motion
No further
to
business?
adjourn?
So moved.
Second.
Take that by acclamation, please. Thank you.